Hi, welcome back to Third Thursday, Lunch and a Divorce Lawyer. I'm attorney Peter Olson, Chicago Family Law Group. Thanks for joining us. This month, I'm excited to have special guest, attorney Daniel Winter. Welcome to our little production here, Dan.
Thank you. Thanks for having me, Peter.
What's a quick nugget? I know you're a bankruptcy attorney. What's a quick description of what you do on a daily basis?
Well, I help people solve their financial problems. So a lot of times people come to me in various different times in their life. A lot of times it's after a major transition and losing a job or something like that, or in the middle of a divorce. So really, my practice area and your practice area really dovetail a lot. And sometimes people have to talk to a bankruptcy lawyer at different times if they get served with court papers, legal papers. But divorce and major life changes really bring into focus what the family was doing and the kinds of debts that they might have.
How has, just a quick nugget before we jump into some, let's call it overlap between divorce and family law. Is there a macro level the pandemic has been how for your world as a bankruptcy attorney?
Well, with the pandemic, people actually benefited in a couple ways on dealing with their debts. One way is that the court system has been very slow. It hasn't not been happening, but people haven't been sued as often. And then there was the moratorium on evictions and foreclosures. So what happened was people got a break because they couldn't work or lost a job or had reduced hours. So the court system and the federal system, the president and everything down in the state courts gave people moratoriums. That meant that they could stay in their houses longer and not deal with the consequences of not paying, and they worked it out with lenders. Also, if they did fall behind, a lot of creditors like credit card companies were giving people a break as well. Now that's starting to end. The moratorium has ended on foreclosures and evictions. And also credit card companies and other lenders are going back to court to try to get people to pay.
Interesting. Yeah, I know just at a super personal level, we outsource the occasional judgment of ours. And I know the attorney who does some of that stuff, said, some of that part of at least the Circuit Court of Cook County, those collection courtrooms are sort of operational again. Whereas I think they were frozen for a while, right? I don't know that world at all, but
well, they might have just permanently, continued these cases several times, but a lot of times it's the backup in getting a court date and getting these cases filed. So people have had over a year break in dealing with a lot of these things, and it's been record lows in bankruptcy filings. You asked how it affected it.
Oh, really?
We've been at record lows for filings, even though the federal bankruptcy court system has been open the whole time. There was not a single day where it wasn't open. There may have been hearings postponed for a couple of weeks, but everything was open. We do all electronic filings in bankruptcy court, so it's available, and all electronic hearings by video in front of the courts, and for bankruptcy creditor meetings, which are the one hearing where if you file a bankruptcy that you have to go to, but now everything's virtual. So we haven't missed a beat in terms of availability, but people just haven't done it because they haven't really had to deal with their financial issues quite yet.
Right. So what, to dig down a little bit, I know bankruptcy is this big thing.
Right.
What are you doing specifically? You're in would it be fair to say consumer bankruptcy, and what does that look like?
I do consumer. I do consumer bankruptcy, and I help small business owners. So if you run a business anywhere from like driving Uber to running a grocery store or a restaurant, I can help you or reorganize your situation and figure out what your best options are. So that's, and another part of the big picture is if you're a consumer, there are two different types of bankruptcy. There's Chapter 7 bankruptcy, which is what you think of as far as debt elimination. It can eliminate credit card debt and medical debt. Chapter 13 bankruptcy allows you to get caught up on a house or a car, so that if you're behind and you're threatened with foreclosure, you can catch up on your house and keep your house. So the perfect example is if somebody lost their job during the pandemic, fell behind with their mortgage and couldn't catch up and couldn't work out a deal with their lender, then they can catch up through Chapter 13 bankruptcy, which is a reorganization, but for people. So that helps people save things as well. So it's not just I lose everything, but it's more like you protect things that you own in bankruptcy as well.
Got yeah. How long does a Chapter 13 plan typically run?
So what happens is Chapter 13 plans run anywhere from 3 to 5 years. The minimum time that you can be ordered to pay your creditors is over 3 years, and the maximum time is 5 years. It doesn't mean you have to pay all your bills back in full. There are certain plans, depending on what you own, you may be able to pay back your bills at 10 cents on the dollar. There are other situations where people have to pay back their bills in full over 5 years. It all depends on their situation. So typically what I do is I have a free consultation with people, and I go through their situation. I tell them exactly what their options are and what they need to do in the case of Chapter 7, or if they're eligible for Chapter 13, what they would need to do. So either way, they'll know exactly what they need to do.
Is there a quick, here's my perception. I haven't seen too many bankruptcies around my world recently, knock on wood, but I feel like these Chapter 13s I've seen over the years would be kind of a person who they still have some income stream and they're often employed, but kind of their debt burden's gotten a little too heavy. Is that sort of a typical 13?
A typical Chapter 13 is if somebody wants, the reason why people file Chapter 13 is if either A, they're making too much money, because there's a means test. It says if you make over a certain amount of money and you don't pass this test, then you need to pay back your bills to a certain degree. That's one type of person. The other type of person is if they own too much stuff. So you're allowed to protect $15,000 per person worth of equity in a house. And if they've got a lot of equity in their house, they may need to do a Chapter 13 to protect their house, to pay back at least that much, the equity remaining. And
Right.
The third type of person would be somebody that has a wage garnishment or is behind on their house or car and needs relief immediately. And if they're behind on their house or car, it would stop the foreclosure, it would stop a repossession right away. So it gives instant relief. It's called the automatic stay in bankruptcy. So that's what Chapter 13 is used for a lot. It's more costly for people, but it's a up to 5 year repayment plan. So I tell people I'm married to them for 5 years because people's income ebbs and flows and stuff. And for a consumer procedure, it's very complicated and very in depth. So you're really in this payment plan and you're with me for 5 years, and it's a lot of work, but it's worth it if you can get through it.
I see. Hey, so can we talk through maybe a little bit, let's call it a generic hypothetical of a couple, right? A couple who might be having some financial issues, while at the same time perhaps considering, maybe splitting up, divorcing or something. So, because that's a common thing. I mean, I don't have my list of. I mean, I probably do have a list, but financial stresses and some of those things are often causal or at least symptoms of marital distress that I'm seeing. So can we, Jim and Jill Smith or something are, maybe having some financial problems, haven't filed a divorce case yet, totally generic. Any thoughts or general guidance on people thinking about timing in terms of filing a bankruptcy?
So there are two different times. Actually, the best time to consider bankruptcy, if you're thinking about divorcing or if you're separated, is before you get the divorce finalized. If you can agree to, even if you don't agree on anything else, if you can agree that, hey, we want to solve, if you've got credit card debt especially, if you want to solve the debt problem ahead of time and agree to file a bankruptcy together or even separately, that's one less thing you'll have to fight about and to pay Peter to divvy up, because then it would cost more to figure out, you have to pay, Citibank MasterCard, I have to pay Chase Visa or whatever, and you split it up, and that takes more of Peter's time and more of your money. Where if you file bankruptcy, if you qualify as a couple, you could file bankruptcy, get rid of that debt, and that's one less thing to worry about and to pay to divvy up. I mean, if you have assets and a house, that's another thing, because then you've got to decide who is going to get the house in the divorce. If there's equity there, when is it going to be sold? Who's going to live there? All those things can impact what happens in the bankruptcy. Because if there's equity there in the house and it's split 50-50, and each of the best thing to do is to sell the house before you'd file bankruptcy. Because if there's a lot of equity, the bankruptcy court could take that as well. Because what the legal fiction is, the bankruptcy trustee, when you file, a trustee steps in and steps into your shoes. But if I was married to Jane Doe and our house had $100,000 worth of equity, and we decided to file bankruptcy, then we wouldn't get to divide up the house, but the bankruptcy court appointed trustee would. But if we sell the house and use the money for whatever we need to do it, and then file bankruptcy, that might be a way to go too. It just depends on how much in the way of assets there are. But for the typical people, they have no equity in their house. But it should be decided, relatively quickly what's going to happen with that house, and to divide up the debts before. Without having to divide up the debts, you can file for bankruptcy, get rid of credit cards and medical bills between the two of you, and then you can figure out what's left. So it's
interesting.
It's really an in-depth conversation that sometimes I end up speaking with the divorce lawyer as well.
If you're doing it during the divorce, obviously, how does that affect timing on the divorce case? Because for a minute or two, and I'm saying not a minute or two, more than a minute or two, that automatic stay is going to pause the divorce case. I think we can lift that pretty quick, but is that the only downside? Little delay maybe in the divorce?
Right. So what happens is, if you filed the divorce case already, the bankruptcy stay does apply, because like we discussed before, the bankruptcy trustee gets to look at all the assets. And if there are assets to divide up, the bankruptcy court gets to look at that, which is why it's better if you see what there is before you'd file divorce. So yes, there's an automatic stay. As far as child support, temporary support, whatever it may be, the stay doesn't apply.
Right.
For child support. So if somebody, for example, the husband has money coming out of his paycheck, $500 every 2 weeks or whatever for child support, that remains, that keeps going. But for property, the stay would stop the divorce and wait until the bankruptcy is over before the divorce can continue. So it can put a wrench in divorce proceedings. So sometimes people file bankruptcy before they even file the divorce proceedings.
That seems like it would be the best move to me. Of course, I guess real world, you're talking about people who might be conflictual and maybe, I don't know, thinking about one another's or mutual best interests might be a little low on the totem pole at that point. But yeah, right. Is there, how long does a chapter, I'm generalizing, but a middle-class family with some medical debt and I don't know, whatever, medical and credit card debt of, I don't know, 50 to 100,000.
Right.
How long does a Chapter 7 take in that sort of a picture?
So in most cases, the Chapter 7 case, what happens is they would meet with me, they'd prepare the paperwork, they would get me documents. And getting the documents usually takes longer than the rest of the case, because they'll need to provide 4 years worth of tax returns and 6 months worth of pay stubs for each of them and their bills. And then they have to do a credit counseling course. And then we get to file the petition. Well, they sign the petition called a bankruptcy petition.
Mhm.
and then we file it with the court. They have a court hearing about 1 month later. And then about 3 months after that is when they get their discharge and the bankruptcy is done. So
Oh, that's super fast.
it's about 4 to 5 months altogether from the beginning when it's filed till the discharge, meaning that it's done.
Wow,
And
that's
that's a short
fast.
time to wait. But if you're in divorce court, you know how long these proceedings can take with the different court dates and negotiations and getting
Mhm.
court dates, with the county, that can take a lot longer. So if you can wait, 4 or 5 months before you've actually filed the divorce proceedings, that might be easier. And I think people need to realize that they don't necessarily need to be friends. They just need to be married to file for bankruptcy together. And so if they can agree to disagree, but say, look, you won't have to pay an extra $5,000 in legal fees, and neither would I, they can save a lot of money if they can eliminate their debt before they even step into divorce court. I mean, this would all be part of the negotiations ahead of time. Or if it's amicable, if only one person has the lawyer and the other person says, you know what, I think we can agree on these things, you could tell them better than that. But if they agree that they would file bankruptcy ahead of time to get rid of the debt, that can save them all a lot of time and money.
That's interesting. Yeah. Because my stereotype, even just starting this call, was, it might delay the court case, the divorce case a little bit, but if you take away a couple big issues, i.e. maybe negotiating a couple debt pieces, I'm not so sure it even really delays the case, the divorce case.
And then the ramifications, though, something to consider is if somebody gets divorced before they file bankruptcy, say the wife gets in the divorce decree that husband has to pay all the debts that are joint.
Mhm.
So, for example, if you have Citibank and Chase and all these other ones that are joint, and it says husband has to pay, and then husband wants to go and file bankruptcy afterwards. Okay. So if husband files, he has to list the wife and tell her he's filing bankruptcy. And then if these companies, so she would have the right, if these companies start pursuing her, then she's going to be very angry, and she can go into the divorce court and say, well, wait a minute, you were supposed to pay these shouldn't be eliminated in your bankruptcy, and create a lot of problems. So then there's more litigation in the bankruptcy court. So it behooves them, it really would benefit them to just get these things taken care of before the divorce. Because what happens is once one person is assigned the debts in the divorce, then that obligation would survive the bankruptcy. See, so if somebody owes Chase Bank $10,000 and files bankruptcy, but it says that that husband has to pay, then the wife could still sue the husband in divorce court and say, well, you didn't pay it. So it doesn't eliminate the obligation to the former spouse. Do you follow me, or did I go too fast?
No, totally. And that makes me think of almost like, I can think of a couple situations, it's almost like a time bomb or a disservice almost to my client if you got this big debt pile that's a joint debt pile.
Right.
And one of those persons does the bankruptcy post-divorce, right? Chase Bank doesn't care what your divorce decree says. And I've run down that road before. I'm just thinking out loud what it was. It was a while ago where some guy, we weren't in the divorce, but he had a piece of real estate like pulled from him because somehow it was a jointly owned with the now ex-wife, and it really jammed him up.
Right. And so it's the joint debts that you need to be concerned about, the ones where both parties are on the debt, or if one is an authorized user. So if you have John Doe got a credit card and added Jane Doe to the credit, or James Doe for that matter, then if only John files bankruptcy, there's still a contract with Jane and Citibank or Jane and Chase. So then they can still pursue Jane. And then I always tell people it's better to agree to file bankruptcy beforehand because then you won't have the angry spouse, going after you. Or if you have to do it separately, to hire somebody like Peter to make sure that all the debts are assigned to the other spouse beforehand.
Yeah.
So it's either the move is, if you're representing one of the parties, the move is to represent one and make sure you have as many of the debts assigned to the other person if you aren't going to agree to file for bankruptcy together.
You just said something. So I'm familiar, right? A joint credit card or something, joint mortgage. That authorized user on a credit card, what does that tie a person to?
That would make that person as responsible as the primary holder on the debt.
That's
so if they have a
interesting.
credit card in their name, they can be held responsible on that debt if they're an authorized user.
So Capital One's just trying to sell me some garbage when they're trying to get me to add my wife as an authorized user. That sounds.
She'd be as responsible as you. Now, it may be in the contract that she isn't, but I wouldn't count on it.
Yeah, that's interesting because I'm always leery, right? I feel like, right, I'll get a credit card or something. I mean, I'm never really applying for a credit card with my spouse. She has her credit, their marital stuff. But when they try to, I always feel like, right, they're trying to sell me that, add an authorized user for some kind of scamish reason.
Well, it's because then they would have two people to go after.
Absolutely. Absolutely. Yeah. That's it. Yeah. Because we just had a divorce case. And I mean, it just came to mind, they had about, 10 to 15 in joint debt. And I know in the initial marital settlement agreement draft, the person who wasn't our client, he was going to pay off part of this debt of our client, but, over time. And I'm like, to our client, it's like, no, because there was a pot of money we could get from. So we got the pot of money because it's like,
you need a lump sum.
Yeah, we got the lump sum because you can't the divorce judgment is not as strong as, discover or so it was someone for one of their adult kids coming after her.
Right.
So.
And then you have a lawsuit and you've got somebody paying, $200 a month. Well, that isn't going to help you if you're being sued on that debt.
Oh, right. And well, that's super interesting, Dan. Tell me about, is this a thing? What's a domestic support obligation?
Oh, right. So in bankruptcy, there's a newfangled term since the 2005 amendments called domestic support obligations. And before, bankruptcy courts just used to talk about it as child support, alimony, maintenance, things like that. Now they have this overarching term called domestic support obligations. So what it means is all of those things. So if you owe your spouse or former spouse any of those things, child support, alimony, I think they call it maintenance in Illinois.
Right.
If you owe them any of those things, number one, they have to be notified of your bankruptcy, be it Chapter 7, Chapter 11, Chapter 13. They have to be notified. Why? Because the bankruptcy system wants to make sure that anybody that's owed, especially an ex-spouse who has to get child support, has to know where this person is and where they're accessible. Number one. Number two, any domestic support obligation is not eliminated, not discharged in the bankruptcy. So it says right in the bankruptcy code, if these are the debts that are not eliminated. One is domestic support obligations. Number three, in a Chapter 13 repayment, they get first priority. So they have to be paid over anybody else. So if you have back child support and you want to file Chapter 13 and reorganize your debts, you got to provide for that back child support 100%. So not only do you have to pay your current support, and that comes out of your paycheck usually, but you have to pay the domestic support obligations, which is any back child support. Now, I've had people that have been threatened to be in contempt of court for not paying their child support. Plenty of things. I'm sure you've dealt with plenty of clients representing them on either side of the equation for one reason or another. They don't pay what they owe in child support. It may be that they lost a job, but they didn't tell the court. Well, you and I know that that's not an excuse. You got to go into court and tell them you're not working. But anyway, if you don't pay the support, that's a domestic support obligation, the back child support. So that has to be paid in full. And I've had people owe $50,000, $60,000 in back child support, and that can throw a whole Chapter 13 out of whack. That's an extra $1,000 a month that they have to pay because it has to be paid in 5 years.
Right.
So it
There-
can be used, though, it can be used to stop a contempt proceeding, and then they have to reorganize it in Chapter 13. It can give people a break, so to speak, but it
Buy a
doesn't give them
little
a break
time.
from, give them time to pay, but it doesn't give them the permission not to pay.
Is there a way to wiggle things into being a domestic support obligation other than the obvious ones like child support or maintenance? Like, you know, you know, Peter has to pay $5,000 on the Chase credit card bill to his
Right.
wife. And this
Right.
is a domestic support obligation. Can we define that or no?
Well, that's a very legalistic question, and the answer,
Fair.
well, right, but the answer is there have been plenty of people trying to define things certain ways, and since Chapter 13 said you can't eliminate a domestic support obligations, a lot of times attorneys have been trying to draft it to say you have to pay, Joe has to pay Jane $50,000 from their retirement account or whatever it is, and they
Mhm.
say, and by the way, this is a domestic support obligation. It has
Yeah,
to
I see.
be, but what the bankruptcy term is, it has to be, you know, not just defined that way, but in the nature of support. There are all sorts of little tests that
Okay.
judges can rule on, and it would go way beyond our conversation here. But we've had people in Chapter 13s, and we've had fights over what is this supposed to be? Is it a domestic support obligation?
Right.
Is it not? So your question is right on point, and it's something that people have tried to do.
Interesting. Yeah, because I see family law attorneys try to, I don't think it's my default, but I see a lot of people try to slip in like some boxed language to define something as a domestic support obligation.
And that's smart, but it has to be in the nature of support. And that's where the judges come in and would have to decide that. And I had a whole fight in a Chapter 13 over, is it in the nature of support? Is it not? Can it be eliminated or modified in a Chapter 13? So we had a several-year fight over that in a very specific case over contributions of one spouse to another to pay for the kids' college.
Interesting.
So it's a very in-depth, very, very fine point on the questions that come up. But you're right, when you're drafting things, lawyers try to get everything in there, and it's better to try and fail than not to try at all.
Right.
As only lawyers know.
Sure. Hey, so just in wrapping up, Dan, where can somebody find you if they need a great bankruptcy attorney?
Right. So I'm at bankruptcylawchicago.com, and my headquarters is in Wilmette. I do virtual appointments for anybody in the Chicagoland area in Northern Illinois. I also have offices where I can meet people in Gurnee and in Palos Heights. But the most important thing is check out the website. I have blog articles on all sorts of topics that I wrote myself. I didn't hire it out. And really, I'm available for any questions. No questions too small. And especially if you get any court papers and you don't know what to do, it's important that you call a lawyer like Peter or like me to see what to do. Because once you get those court papers, what you do with your assets can determine what's going to happen. Right.
Is there, I don't know, here's my ideal client, or, you know, this is kind of the most typical kind of segment I'm of a person I'm working with? Or
my most typical clients are two people that are working and have a house and a car or two and are just struggling to keep things going and have had to use credit cards to make up the difference in their paychecks. That's one typical client. The other typical client is somebody who's fallen behind in house or car obligations and needs a way to catch up. You know, for example, job loss. I mean, this is going to be huge. Eventually, after the pandemic, everything sorts out. People are going to need to figure out how to catch up on things.
Super interesting. Hey, this isn't a 30-second question, so I'm hesitant to even ask. What's the latest on student loans with regards to bankruptcy? Is there anything,
Right.
any movement in that area? Because I mean, right, that's a time bomb for young adults.
It isn't a 30-second question, but the bottom line is student loans generally, unless somebody's disabled and can't work, cannot be eliminated in a bankruptcy. There's certain things I can do to help people in a bankruptcy, put them in a Chapter
Right.
13,
Right.
and help them pay what they can afford. Also, the thing people need to look for in student loans outside of bankruptcy is what kind of loan is yours. And I did a little video on this during the pandemic with my pandemic beard. But really, people should look to see, are their loans federal loans or are they private loans? Because
Right.
the difference is federal loans have all sorts of different programs, and we may get a whole slew of new programs come next year with
Yeah.
this administration looking into what they can do on student loans. Because
Right.
federal loans have a lot more options. They're all still on a break, so to speak, and there's no collection on them right now until the end of January of next year. But people should figure out what they are. Private student loans are like borrowing for school on a credit card, and they can pretty much do whatever they want right now in terms of requiring payments, suing people, and things like that. But you know, the most important thing is to call a lawyer. I deal with student loans as well as bankruptcy.
Interesting.
So
Yeah.
they dovetail, but you're going to see reports of people, they got their student loans wiped out. They're very, very specific rulings, and judges, you know, really are constrained by the law in terms of eliminating student loans. They're
Got it.
really, you have to really be able to not be able to work for the foreseeable future to get rid of student loans in bankruptcy.
Interesting. Hey, well, thanks again for jumping on here, Dan. Attorney Daniel Winter, and I think I heard your website as bankruptcylawchicago.com. So
Right.
check them out there. And I know you're my business partner for bankruptcy referral. So people who call me, I'm giving you. So thanks again for sharing your expertise.
Thank you, Peter. Good to talk to you. And you know, if anybody has questions about divorce, I would always send them your way as well.
Cool. Thanks a lot, Daniel. Bye.
Okay. Thank you.